We're here on the record, and this is the matters of people of the state of Michigan versus Matthew John Layman. These are four different files: 25-3400FH, 25-3401FH, 25-3402FH, and 25-3404FH. Counsel, if you could place your appearances to begin, please.
Jeremiah Buffalo Wargo P77997 on behalf of the people.
William Pfeiffer P45236 on behalf of Matthew Layman.
Thank you. And sir, are you Matthew Layman? Sir, are you Matthew Layman?
Am I Matthew Layman? Yes, I am.
All right. Mr. Layman, we're here today. Counsel, I'll start by addressing you. I'm Judge Hunter. I'm from the 46th Circuit Court, which is Crawford, Otsego, and Kalkaska. I've been assigned by the State Court Administrator's Office. I know this is an Alpena County 26th Circuit Court case. I want to first make sure I'm here for the right purpose in terms of my understanding. It looked like this was an arraignment on an information. Is that accurate, Mr. Pfeiffer?
It is, Your Honor.
Have you had a chance to go over all of those informations, the various four different cases with Mr. Layman?
Your Honor, I was not able to go over it today, but I have went over it with him in the past, yes.
Mr. Layman, you appear demonstrative to me, and you were just making this motion with your hands. I don't know what that means, so why don't you try to explain it for me?
Oh, you were just asking him if he just went over everything with me. We didn't have enough time to go over everything. There's a lot more I want to go over with him.
Well, I'm sure there's many more things that you want to go over, but the purpose of this hearing is relatively limited. That's why I asked your attorney. But now I'll ask you. The purpose of an arraignment on an information is to determine whether or not you've reviewed the charges against you, whether or not you understand them, and whether or not you understand the maximum penalties. That is not a question of whether or not you agree with the charges, or if you need more time to talk with your attorney about them. That's why the limited question to your attorney was what it was. So the question for you, Mr. Layman, is, do you want me to read the charges on the open court record, or do you know what the charges are?
I have some idea what the charges are and what some of the maximum sentences are.
Well, some is not appropriate to this court, and so what I'll do is take the time that's necessary to go through each and every one of the charges, Mr. Layman, because it's important that you understand them. More specifically, it's more important to me that you're aware of them. I can't possibly force you to understand them or agree with them, but I will make sure that you have every opportunity to understand the nature of the charges. In the first file that's been filed against you, Mr. Layman, your charges are the following. The prosecutor has alleged by the information that he's filed that on or about 7/21 or July 21st of 2025, with regard to count one, that you did threaten to commit an act of terrorism and did communicate that threat to another person contrary to statute. That offense, if you're convicted of it, is a felony offense, and the maximum punishment for that felony is up to 20 years in the state prison system and or a fine of up to $20,000. You must reimburse the government for expenses incurred from the violation if the court so orders if you're convicted of that offense. Do you understand the name of that offense and the maximum penalty?
Yes, I do, Your Honor.
Count two in the information there charges you with the offense known as false report of a threat or terrorism, and that alleges that you did threaten to commit an act of terrorism and did communicate that threat to another person contrary to statute. Again, count two is a felony offense. The maximum punishment for that felony is up to 20 years in the state prison system and or a fine of up to $20,000. The court has the opportunity to order you to reimburse the government for expenses incurred from a violation of that statute. Finally, in count three, you're charged with the offense of interfering with the crime report. The prosecutor alleges that you did retaliate or attempt to retaliate against another person for having reported or attempted to report a crime committed or attempted by another person contrary to statute. That particular offense is a misdemeanor offense, and the maximum punishment is 1 year in the county jail and or a $1,000 fine. The consecutive sentence may be imposed for any other conviction. Are you now aware of the charges that have been filed against you and their maximum penalties in that file?
Yes, I am, Your Honor.
Turning to file number 25-3401FH. In that particular case, the information charges you with the offense of count one, malicious destruction of fire or police property. In that case, the prosecutor charges that on or about July 21st of 2025, that you did willfully and maliciously destroy or injure certain personal property, to wit, a security or surveillance camera belonging to or possessed by the Alpena County Jail contrary to statute. That offense is also a felony offense, and the maximum punishment for that felony offense is 4 years in the state prison system and or a fine of up to $5,000. Did you have a question, sir?
Oh, no, I was just pointing out, I'm in the exact cell where I did it. It was that camera up there that I broke
Mr.
with the
Layman, let
room.
me make this more simple for you. This is not a hearing where I'm making factual determinations. This is not a hearing where I've yet sought input from you except as to limited questions. And those limited questions are these following. Have you had a chance to read the allegations against you? Do you understand the charges? And do you understand the maximum penalty?
Yes,
That's it. That's all I'm asking, and that's all I'm permitting. So any of the commentary that you might have, you can save it for your attorney and or for a jury and or for me if you determine to have a bench trial. But the focus of this hearing is not for you to tell me anything else about the case. Do you understand?
Yes, I do, Your Honor.
So do you understand the nature of the charge and the maximum penalty associated with count 1 in the second file?
Yes, I do, Your Honor.
Count 2 charges you with the offense of malicious destruction. Mr. Layman, I intend to keep talking, and I'm going to keep talking because you are already tending to make this job more difficult than it needs to be. I say that because this is a simple procedure. And when you're laughing, it suggests to me more that what I'm suspecting is the truth, that you're intentionally trying to impede the role that I have, the role that Mr. Wergau has, the role that the Alpena County Circuit Court has, or the role that even your own attorney has. If my suspicion in that regard is continued and I make a finding, I'm simply going to remove you from this court proceeding and I'll conduct it with your attorney. However, that's an extreme measure. I don't want to take that action. But I am not going to allow you to turn this hearing into a mockery. And if you continue to act like this is a funny proceeding, I will view you as having waived your right to participate. Do you understand what I've said?
Yes, I do, Your Honor.
Do I need to repeat any of that circumstance more specifically for you?
No, you do not, Your Honor.
Then you should act accordingly. You should listen carefully to the things I'm saying, and you should answer only those inquiries that I put to you. Count 2 in the second file, 25-3401FH, charges you with the offense of malicious destruction of fire or police property. If convicted, that also is a felony offense. Maximum potential punishment, up to 4 years in the state prison system and or a fine of up to $5,000. Do you understand the name of that offense and the maximum penalty?
Yes, I do.
Count 3 charges you with malicious destruction of fire or police property. It alleges that you did willfully or maliciously destroy or injure certain personal property, to wit, a broom belonging to or possessed by the Alpena County Jail, contrary to statute. Again, that offense is a felony offense. The maximum punishment is 4 years in the state prison system and $5,000 maximum fine. Do you understand the maximum penalty associated with that offense?
Yes, I do, Your Honor.
Each of those 3 counts are subject to what's called a habitual offender second offense notice. If you are convicted as a habitual offender second offense notice, the effect is that each of those felony offenses is punishable by 1.5 times the amounts that I just said. So for example, count 1, count 2, and count 3, rather than having a 4-year maximum, would have a 6-year maximum under the statutes. Do you understand that maximum penalty?
Yes, I do, Your Honor.
With regard to file 25-3402FH, Mr. Layman, you are charged with several different offenses therein. With regard to that case, the prosecutor alleges that on or about July 21st of 2025, in count 1 that you committed the offense of home invasion first degree. The allegation reads and claims that you did break and enter or did enter without permission a dwelling located at 1000 US 23 North, and while entering, present in, or exiting, did commit an assault, and while entering, present in, or exiting the dwelling, Brandy Allen Bridges was lawfully present therein, contrary to statute. That offense, if you're convicted, is a felony offense, and the maximum punishment for that felony is up to 20 years in the state prison system and or a fine of up to $5,000. That offense is also punishable by consecutive sentencing if you're convicted of any other conviction arising from the same transaction or occurrence. Do you understand the nature of that charge and its maximum penalty?
Yes, I do, Your Honor.
In count 2, you're charged with the offense known as criminal sexual conduct in the 4th degree, force or coercion. The prosecutor reads and alleges that you did engage in sexual contact with another person, to wit, Brandy Allen Bridges, using force or coercion to accomplish the sexual contact contrary to statute. Do you understand that allegation so far?
Yes, I do, Your Honor.
That is a tier 1 offense under the Sex Offenders Registration Act if the victim was 18 years of age or older. It's a tier 2 offense if the defendant has a prior conviction for a tier 1 offense. It's a tier 2 offense if the victim was between the ages of 13 to 17 inclusive. And it's a tier 3 offense if the victim was under 13 years and the defendant was 17 years of age or older. It's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Take notice that pursuant to the statute, upon bind over, to the circuit court, the district court judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV. If that judge determined that there's a reason to believe that the violation involved sexual penetration or exposure to a bodily fluid of the defendant. If the district judge made that determination that testing is not required, then upon conviction, the court must order you to be tested. Do you understand those provisions?
Yes, I do, Your Honor.
The maximum penalty for that offense, it's called a high court misdemeanor. In Michigan, that's also known as a felony. That's because it's punishable by more than 1 year in the county jail. The maximum penalty for that offense is 2 years in the state prison system and or a fine of up to $500. Are you aware of that maximum penalty?
Yes, I am, Your Honor.
Count 3 charges you with the offense of police officer, assault, resist, or obstruct. It alleges that you did assault, batter, wound, resist, obstruct, oppose, or endanger Terry Curtis, who was a police officer with the Alpena Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to statute. That offense is a felony offense with a maximum punishment of 2 years in the state prison system and or a fine of up to $2,000. A consecutive sentence can be imposed under one statute if the assault was committed in a place of confinement or under a separate statute for another violation arising from the same transaction or occurrence. Do you understand the nature of that charge as well as its maximum penalty?
Yes, I do, Your Honor.
Again, for these charges, the prosecutor suggests that you are a habitual offender second offense notice. If that's found by the court to be true, that means that each of the penalties that I've just outlined is increased by 1 1/2 times. That means count 1, home invasion first degree, could carry with it a maximum of 30 years in the state prison system. Criminal sexual conduct fourth degree in count 2 could carry with it a maximum of 3 years in the state prison system. And count 3, police officer, assault, resist, or obstruct, could carry with it a maximum of 3 years in the state prison system. Are you aware of those maximum penalties under the habitual claim?
Yes, I am, Your Honor.
Finally, in claim 25 case number 25-3404FH, the prosecutor alleges that on or about July 11, 2025, with respect to count 1, that you did make an assault upon Thomas Michael Patel Jr. by strangulation or suffocation, contrary to statute. That is a felony offense with a maximum potential punishment of up to 10 years in the state prison system and or a fine of up to $5,000. DNA must be taken upon your arrest. If it was not taken upon your arrest, it would be ordered to be taken upon your conviction. A consecutive sentence may be imposed under the statute if the assault was committed in a place of confinement. Do you understand the maximum penalties associated with that charge?
I do, Your Honor.
You're also charged as a habitual offender second offense notice, meaning that if you were convicted, that penalty would rise by 1 1/2 times, meaning the maximum penalty is 15 years in the state prison system for count 1. Do you understand that?
You.
Count 2 charges you with the offense known as assault with intent to maim. That alleges that you did make an assault upon Thomas Michael Patel Jr. with the intent to maim or disfigure said person by cutting or tearing off an ear, contrary to statute. That is also a felony offense. That felony offense is punishable by a maximum of 10 years in the state prison system and or a fine of up to $5,000. DNA must be taken upon your arrest. If it was not taken upon your arrest, it would be ordered by the court to be taken in the event you were convicted, and a consecutive sentence may be imposed under the statute if the assault was committed in a place of confinement. Once again, you're charged as a habitual offender second offense notice, making the maximum penalty for assault with intent to maim up to 15 years in the state prison system. Do you understand the nature of that charge as well as its maximum penalty?
Yes, I do, Your Honor.
You have the right to remain silent throughout these proceedings. If you don't remain silent, anything that you say on the open court record or in any writing could be used against you. You have the right to be represented by counsel. Here's Mr. Pfeiffer is going to do that adequately for you. Mr. Pfeiffer, with that reading, do you have anything formally that you would like to cover further in terms of the arraignment on the information?
There's just one issue. I'm not sure if Mr. Wergo is aware of this, but count 2 of the last file, the assault with intent to maim, was dismissed at the district court level. So
I was not aware of that. I appreciate that clarification. Is that correct, Mr. Wergo?
I do believe it is, Your Honor.
All right. And so all of the other charges, though, still remain. Is that right, Mr. Pfeiffer?
Absolutely, Your Honor.
All right. So that is a fair and important clarification. Count 2 in that last file, assault with intent to maim, has been dismissed. Are you now aware of that, Mr. Layman?
Oh, yes. Yes, I am, Your Honor.
All right. Then with that, would you ask that not guilty please be entered on behalf of your client, Mr. Pfeiffer?
I do today, yes, Your Honor.
My ordinary practice is that after an arraignment, I'll give the defense attorney, typically an option. We can either move right into a pretrial or a status conference, or at your request or at Mr. Layman's request, and it seems to be his, we could set this out for a new status conference and give you further time to discuss with Mr. Layman. If that delay comes from his request, obviously that would affect how quickly he could have anything done in this case. But I generally would leave that to you. Did you have a request for the court today, Mr. Pfeiffer?
Judge, I would like a little bit of time upon bind over and my discussions with Mr. McLennan. It was anticipated that we'd have some discussion about a potential resolution. We have not been able to do that yet, so I'd like a little bit of time to try to do that if the court is willing to give us that time.
Mr. Layman, you understand that if I grant your attorney's request for an adjournment, it's going to do several things. Number one, it will give you more time to talk with him, which sounds like you had asked for. But number two, it's also necessarily going to prevent you from doing anything else in this case. For example, asking me to set the matter for trial or accept a plea. So it's going to slow down that process. Do you understand?
You know how long it will do that? Do you have any idea?
My typical motion days, and it will be a little bit different in this case. I typically have criminal motion days about once a month. In some counties, I'm in 3 different counties, so this would be the 4th. In some counties, I have status conference or plea hearings every 2 weeks. But in the 26th Circuit Court, it's a little bit more difficult because I have to coordinate with 26th Circuit Court staff. My staff has to coordinate with the other attorneys' offices. So it's not always as quick. So the answer I can give you is I could try to schedule this for another hearing in about 2 weeks, or I could schedule it in about a month. But generally, that's what we're going to be looking at.
Well, the sooner the better. I would like to.
Well, do you want me to try to schedule a hearing in about 2 weeks?
Yes, that's okay with everybody else.
Mr. Pfeiffer, do you think if I give you that 2-week time frame that would reasonably give you time to both discuss with the prosecutor as well as with your client?
It would, Your Honor.
And Mr. Wergow, on behalf of the people, do you have any opposition to an adjournment of that nature?
We would support it, Your Honor.
All right, so I'm not going to guarantee that exactly 2 weeks from today will be the next hearing, but I'll do my best to put it right about that time frame. As again, I've already said, I've maintained dockets in 3 counties already in the 46th, and scheduling when you add another county is more difficult, but I'll make every effort to get this matter on within that approximate 2-week time period. Mr. Pfeiffer, anything else you wanted to cover today?
No, Your Honor.
Mr. Wergow, anything further on behalf of the people?
No, Your Honor.
All right, thank you. We'll see everyone in about 2 weeks. For now, we're going to be conducting these matters via Zoom. If there's a specific need for an evidentiary hearing or otherwise where in-person proceedings would benefit the parties or the court, attorneys, you can bring that up to me and I'll consider it. But for now, we're going to consider these matters via Zoom.
Okay.
Thank you.
All right. Thank you very much, Your Honor.
Thank you.
Thank you, everyone.
Thank you. The court will be in recess on these matters. All right, welcome everyone. The court is on the record now and calls the matter of people of the state of Michigan versus Brooks Michael Weston, file 25-5105FC.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Cedar appearing with and on behalf of Mr. Weston.
Thank you, sir. Are you Brooks Michael Weston?
Yes, sir.
Mr. Weston, I'm Judge Hunter. I'm appearing today from Crawford County, but as you know, this is a Kalkaska County matter. I'm sure your attorney filled you in on the details, but I want to make a more formal record briefly of that. I tried to call your case on Wednesday. You were apparently in the Wexford County Jail. That was what my docket indicated, but we didn't see Wexford County. At one point, I took a break and Mr. Seeger tried to reach out to the county as well as did the probation staff to see if they could get you there. At one point, a court officer from Kalkaska was given information that you were not present in Wexford County. Your attorney made an impassioned plea to have me set this matter as quickly as I can, and I offered to do just that because I agreed with him ultimately that we needed to get this case heard. However, the information I had was a combination of confusing to me because the Wexford County, somebody told us that Wexford County did not hold you. Your mother was also in the courtroom. She let me know that she received a communication via email from you that morning. It was her impression that you were still in Wexford County. So I was left very confused. All I knew was that you were not present and I ultimately could not proceed. But I made myself available on today's date because your attorney expressed that it was very important, and I tend to agree with him. It's important for you to be heard quickly. Is that background, I know there was more to it, Mr. Seeger, but is that background a fairly accurate background?
It is, Your Honor. He appreciates that the court was able to accommodate him.
All right, and Mr. Ziegler, is that a fairly accurate background?
It is, Your Honor.
So, Mr. Weston, even though there was some mix-up with the Wexford County Jail or Kalkaska or my staff or whatever it was, have you been able to maintain good communication with Mr. Seeger?
Yes, I have.
All right, Mr. Seeger, what is the status of this case then?
Your Honor, it's my understanding that Mr. Weston is going to tender a plea to 1 count of resisting and obstructing. In exchange, the enhancement would be dismissed.
that a correct statement of the plea offer?
It is, Your Honor.
So that'd be count one for dismissal of the habitual force.
Correct.
And Mr. Weston, did you hear the terms of that plea agreement?
Yes, Your Honor, I did.
Do you understand the terms?
I do.
And did you wish to take advantage of a plea offer under those terms?
Yes, Your Honor.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Mr. Weston, under this plea agreement, you're going to be pleading guilty to the offense known as count one, police officer assault, resist, or obstruct. If you're convicted of that offense, it is a felony, and the maximum punishment for that felony is up to 2 years in the state prison system and or a fine of up to $2,000. Are you aware of that?
Yes, Your Honor.
If the court determines that the assault was committed in a place of confinement, then I could order consecutive sentencing. And if I find that the conviction arose out of another violation arising from the same transaction, I could also consider consecutive sentencing. Do you understand that?
Yes, Your Honor.
If I determine that you were on felony bond at the time you committed this felony, then I could order consecutive sentencing on that basis. Do you understand that?
Yes, Your Honor.
And if I determine that you were on parole status at the time you committed a new felony, then I would have to sentence you consecutively. Are you aware of that?
Yes, Your Honor.
And are you aware of what consecutive sentencing would mean for you, or would you like me to explain it more fully?
I think I understand, Your Honor.
All right. So in terms of the habitual offender notice, the benefit of the plea agreement is if you plead guilty to count one, the prosecutor would dismiss the habitual offender fourth offense notice, which would have had the effect potentially of making the felony up to a 15-year felony instead of a 2-year max. Are you aware of that benefit?
Yes, Your Honor.
Understanding the benefit of the plea agreement as well as the maximum penalty you face under that agreement, how do you plead to the offense known as a police officer assault, resist, or obstruct?
Guilty.
If you plead guilty, you no longer have any automatic rights of appeal. Instead, after a guilty plea, you would have to ask for leave to appeal, which is permission granted, not by right. Are you aware of that?
Yes, Your Honor.
If you plead guilty, you no longer have any of your current trial rights. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you would have a right to have the witnesses against you appear and to see, hear, and question them. You'd also have the right to have the court order any witnesses on your behalf to be ordered to appear at trial. You'd have a right to remain silent and not have that silence used against you, and you would have the right to testify at trial if you wanted to. But if you plead guilty, you give up those trial rights. Are you aware of that?
Yes, Your Honor.
And because you're giving up your trial rights, you also necessarily give up the right to challenge other things that you might have been able to challenge if you did have a trial. Do you understand that?
I think so.
So, for example, if you had a jury trial and the prosecutor set forth evidence that you thought should not have been able to come in, you might be able to file a request to appeal on that basis. But since you're not having a trial, you can't appeal from things that might have happened or would have happened at trial. You understand?
Yes, sir. Yes, Your Honor.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily?
Yes.
Is it your choice to plead guilty?
Yes, sir.
Mr. Ziegler claims that this offense happened on September 11th, 2025 in Kalkaska County. Do you think that date is accurate?
Yes, sir. Yes, Your Honor.
Were you present in Kalkaska County on that date?
Yes, Your Honor.
On that date, did you come into contact with Deputy Anthony Nigersall?
Yeah, yes, Your Honor.
And whether or not you knew it was Deputy Nigersall, did you in fact know it was a deputy with the Kalkaska County Sheriff's Department?
Yes, Your Honor.
And did you know, or did you have reason to know that that officer was performing his lawful duties?
Yes, Your Honor.
Well, was he dressed in full uniform?
Yes. Yes, he was.
And you knew he was a police officer, correct?
Yes, Your Honor.
Did you do something to resist, obstruct, or oppose his lawful commands, or otherwise assault or batter or wound him?
Yes, I did.
What happened?
Where do you want me to start, Your Honor?
Well, what's the general factual circumstance? You come into police contact, you know it's a police officer, he tells you to do something, what do you do?
I was in the bathroom at my parents' house, and I heard some people coming into my house. They later identified themselves as officers of the law. I jumped out the window in the bathroom, and I started running towards the backyard of my parents' house, and someone came out of the bushes in the backyard and yelled at me to get down, and he Yes, sir. He had identified himself as a police officer and I just kept running.
So after the point at which you were sure that it was a police officer because they identified themselves as such, you continued, at least for a point, running or trying to flee from their lawful command or authority?
Yes, Your Honor, I kept running.
All right. Counsel, is there an adequate factual basis?
Yes, Your Honor.
Yes, sir.
Do the attorneys believe the court has complied with the court rule regarding the taking of pleas?
Yes, Your Honor.
Yes, sir.
And are either one of the attorneys aware of any promises, threats, or inducements not disclosed on the record?
No, Your Honor.
No, sir.
Mr. Weston, I find that your plea is knowing, voluntary, and accurately given, and based upon what you've told me, there's a clear factual basis to support a finding of your guilt. So I'll accept that plea and enter it on your record. The next step is the Department of Corrections is going to reach out to you there in the jail. They're going to interview you, and that interview will result in what's called a pre-sentence investigative report. That'll tell me more about you and more about this event and your background. Ultimately, then I'll have you in the courtroom for a sentencing hearing. So for that sentencing hearing, which will be in about a month, you'll be there in Kalkaska County Circuit Courtroom. So will the prosecutor, the defense attorney, and myself. Do you have any questions about any of that?
No, Your Honor.
Mr. Seeger, anything further?
No, sir.
Mr. Ziegler, anything further?
No, Your Honor.
All right, then thank you everyone for accommodating today. Mr. Weston, we will see you in about a month.
Thank you, sir.
Thank you.
Can I have your name, please?
Randy Dennison.
Thank you. You are the victim that's in this offense that Mr. Owen is here for today. Is that correct?
Yes, sir.
The court calls next the matter then of people of the state of Michigan versus Theodore Brian Shane Owen. This is file 25-18163SM. Mr. Thompson, you're here as duty attorney for Mr. Owen, correct?
Correct, Your Honor.
Sir, are you Theodore Brian Shane Owen?
Yes, Your Honor.
Mr. Owen, I'm Judge Hunter. I'm covering today for Judge Burmeister, who's not available. This is an arraignment on two different issues. Well, it's an arraignment on one issue, and I'm going to set two different dates into the future. It's an arraignment on an allegation that you were in contact with Ms. Dennison, who's the victim of the domestic violence offense to which you pled. The allegation was that you had violated a conditional release order. That would be a bond condition that said you cannot have contact with her. Do you understand the nature of that allegation?
Yes.
If you're found guilty of that violation, the court could take several different terms of action. The court could revoke your bond. The court could set the matter for a contempt hearing, at which time you could have the prosecutor bear the burden of proving that you violated the bond condition. The court could always otherwise take action on your bond by reducing or raising the amount of the bond or adding terms or conditions to the bond. Do you understand all of those things?
Yes.
So what I'm going to do, Mr. Owen, is I'll hear from your attorney. Ultimately, I'm going to set a couple of dates for you, though. One is for a sentencing date. My understanding is that you had already entered a plea and that there was a sentencing step, but it hadn't yet come. So I'm going to set a sentencing date on the underlying conviction. That will be November 18th of 2025. That will be at 9:00 a.m. in the district court. I'm also going to set a probation violation hearing, or more specifically, the bond violation hearing for that same date and time. Those will both be in front of Judge Burmeister. You'll get a copy of those. I'm also going to hear from Mr. Thompson in between what I should do in between now and that date in terms of bond. Mr. Thompson, did you have a suggestion?
Your Honor, Mr. Owen was asking that the court set a PR or low cash bond. I will indicate Mr. Owen had intended to plea today to this allegation. I do think it's appropriate to have Judge Burmeister address both this underlying allegation and the case at that sentencing on the 18th. So we would ask if the court would consider.
Let me ask a clarifying question, please. You said he intended to plead. Are you talking about plead to the bond violation? He has already pled to the domestic violence, correct?
Yes, as to both.
Okay, and that affects things at least a little bit. My suggestion, Mr. Thompson, is I'll certainly allow you to articulate anything else. But if that's the way you plan on proceeding, let's take care of the plea first. Then I can address bond on the bond violation issue and set those dates out in the future. Any problem with that?
No objection.
Mr. Owen, did you hear what your attorney just stated?
Yes, Your Honor.
So if that's the course of action you intend to go down, raise your right hand. You solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Again, bear in mind what I've already said. If you're convicted of violating the court's bond order, this court could take action. I could decide to defer to Judge Burmeister for him to take action, or I could take action myself, depending on what I found after this hearing. regarding all of those things I've already said. I could raise your bond, I could revoke your bond, I could increase or add conditions to your bond, and I could do a variety of other things under the court rules. Do you understand?
Yes, Your Honor.
Is it your intention to plead guilty to violating your bond conditions?
Yes.
You understand that if you plead guilty, you will not later have the right to have a contested hearing regarding that issue. In other words, you're admitting it, you won't be able to contest it or challenge it later. You understand?
Yes.
And
Yes,
has
I
anyone
understand.
has anyone promised you anything to get you to plead guilty?
No.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No.
Is it your own choice to plead guilty?
Yes.
So, Mr. Owen, it appears that you were on bond, and this was on yesterday's date or today's date even. It was 11/6, I'm sorry, at 2025, approximately 4:30 yesterday. You knew that you were on bond for a domestic violence case to the district court, correct?
Yes.
You knew that one of the bond conditions was that you could not have any direct or indirect contact with Ms. Dennison, correct?
Yes.
And on yesterday's date, when the officer came into contact with you both, you were in direct contact with her, correct?
Yes.
Court accepts your plea, finds it to be freely, knowingly, and voluntarily given. Mr. Thompson, do you agree there's an adequate factual basis?
I do, Your Honor.
The court will accept your plea then. I'm going to continue those other two dates, but it's going to be a bond violation sentencing hearing. I'm writing in that word because, again, I already pled guilty to that. Now, as the bond in between now and the time of that hearing on the 18th of November, Mr. Thompson.
Your Honor, in terms of the substantive allegations here, my understanding from Mr. Owen is that his fiance, Miss Dennison, had contacted him. She has a vehicle, Mr. Owen does not. She was not able to drive because of some medication she had to take. The children needed to be picked up. She couldn't find someone to help. She asked Mr. Owen to help. He shouldn't have done it because of the bond circumstance, but he did. So when they were pulled over, it's my understanding there was no instances of violence. There was no safety risk. There was a violation of the court order. Mr. Owen understands that. However, I think a low cash bond is appropriate under these particular circumstances. Thank you.
Ms. Dennison, because you're here, I'll give you the opportunity to speak. The question that I'm phrasing really is limited to the bond violation in terms of what you think I should be aware of with that bond violation. You'll also have the opportunity to speak later when it comes to the domestic violence sentencing and ultimately the bond violation sentencing, which will be in front of Judge Burmeister. So in terms of the bond considerations, do you think I should be aware of anything?
No, I think he should have a bond.
Mr. Owen, this case presents, thank you, Ms. Dennison, this case presents as fairly typical, but nonetheless problematic for you. There are clear bond conditions, and those bond conditions are in place for a variety of reasons, but independent of whether or not there are good reasons for them being in place or whether or not you agree with the fact that they're in place, they are in place and they're valid existing court orders. You are the one who's subject to peril if you violate them. You're subject to that peril today in front of me for the bond violation that you just pled to and in front of Judge Burmeister for the underlying domestic violence offense and for the bond violation. My view is that the night you served in jail right now, given the circumstances as I know them, is sufficient for this bond violation. But let me be ultimately clear to you, Mr. Owen. If I find, and I'm the judge that's handling it, that you're again in violation of the bond conditions by being in contact with Ms. Dennison before your November 18th date, I'm going to view it as an intentional violation more than even this first one. And it will certainly be met with further and higher consequences than this one day in jail that you've already served. Do you understand what I mean?
Yes, Your Honor.
So I'm going to reinstate whatever prior bond you had effective immediately, pending the sentencing hearings before Judge Burmeister. Certainly, it's my view that Judge Burmeister has a better handle on the circumstances of this event. It's his case, and he presided over the plea in this case. And I'm certain that he will take into account all of this circumstance when he imposes sentence. So pending that sentencing hearing on November 18th, I'll immediately reinstate your bond, and you'll be free to go as soon as that's transferred through the Crawford County Jail. Mr. Thompson, anything further today?
Nothing further on Mr. Owen's case. Thank you.
So I have a question.
Go ahead.
So you're reinstating my bond and I get released until my sentencing date on the 18th, correct?
Unless you're held on some other matter, Mr. Owen, I don't know your specific circumstances,
No.
but in terms of this bond violation, I'm finding that your bond is going to be reinstated, the bond that you previously posted, pending and
Okay.
until Judge Weiss your sentence.
Okay,
All right, thank you, Mr. Owen. Please let the jail staff know that we're ready on the next individual, Ms. Huffman. Thank you,
Okay.
Ms. Dennis, for being here.